Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to discuss with you a couple of misconceptions about domestic violence and about domestic violence restraining orders, and also to provide 3 steps to take action on what to do if you find yourself charged with a domestic violence offense, and particularly if there's overlap with a domestic violence restraining order outside of criminal court. So a parallel family court hearing as well. Let's first start with 3 common misconceptions related to domestic violence. And the first is, well, my girlfriend's going to drop the charges, so I don't need a lawyer. Could not be further from the truth. Your girlfriend, your boyfriend, your husband, your mom, your sister, whoever, after reporting a crime, certainly has a right to make their voice heard, to say, I don't want my husband, my son, whoever, prosecuted. But that's just a request. Doesn't mean that's what's going to happen, especially in domestic violence cases. Well, why? Well, one is, it's law enforcement's job to investigate no matter what the alleged victim wants to do. And it's also a prosecutor's job to prosecute a crime, irrespective of what the alleged victim wants. It sounds kind of funky, but that's the truth. And why, especially in domestic violence context, why? Because a lot of times what law enforcement sees, a lot of times what district attorney sees, a lot of times what even us as defense attorneys see are this whole, you hear about this cycle of violence. Well, there's something happens, and then there's a honeymoon phase, and people get back together again, and they don't want to see the other party, their loved one, get in trouble. So they try and abandon the charges and just let it go. And then something allegedly happens again, and round we go. So, law enforcement and prosecutors are very mindful of this, and they'll certainly consider what the alleged victim of a crime wants in a domestic violence context, but it's not the end-all, be-all. Second misconception is, well, if I just push this case to trial, it's going to get dismissed. They're not going to want to go to trial on something like this, right? A low-end misdemeanor, domestic violence, even as a felony where maybe someone's not actually physically harmed. Well, not necessarily true either, right? Because sometimes pushing a case to trial, even if it's not a great case, may work out to your benefit. You might not really have a whole lot to lose. It might only get better, especially with the right facts, especially with, the right timing, depending on what's going on with the court congestion, depending on what's going on with the prosecutor's schedule, what's going on with their witnesses' schedule and their witnesses' lives, and who you have representing you. What does the prosecutor think about your law firm? Do they have a reputation for going for trial? Do they have a reputation of being difficult to get convictions against? All those things factor in, but just this belief that, I'm going to push you to trial. It's not traffic court. It's not you set a thing for trial and the cop doesn't show up, you win, you go home. It's a criminal charge. It may work out in your favor, it might not. How do you make that assessment? Well, with the help of a quality criminal defense attorney who's experienced in that courthouse, experienced with those prosecutors, experienced with those judges. And then he or she can advise you accordingly on reasons why you might want to push the case to trial, reasons why you might not. The third misconception we see a lot is that, well, it's just a misdemeanor domestic violence conviction. No one got hurt. All right, I'll do these classes for a year and I'll be on probation, big deal. It's really not going to have any impact on me. Is it going to have an impact on your professional license? If you get convicted of a crime, let alone a crime of violence, a misdemeanor domestic violence offense? Is it going to have an effect on your immigration status if you're not a United States citizen? Is it going to have an effect on your ability to obtain and maintain a firearm, possess a firearm? If you have a misdemeanor domestic violence offense? Is it going to affect your ability to obtain and maintain lawful employment? Get a good job, keep a good job. Very well could, as an answer to all those questions. So you want to make sure that you're assessing all options, short-term and long-term, when determining whether to plead guilty to a misdemeanor, even a misdemeanor domestic violence offense, certainly a felony. But you want to work with your attorney to make sure that he or she is thinking big picture, right? Okay, it may not be too difficult to get you out of this without going to jail. But how's this case going to affect you in 3 weeks? How's this case affect you in 3 months? How's this case going to affect you in 3 years? All things that your attorney and your law firm should be talking to you about. Because if they're that short-sighted and only looking to get you the best deal for today, then they're really not doing their job, and they're certainly not doing their job effectively. Well, 3 things now, right? We talked about 3 things, 3 misconceptions, 3 things to take action. First thing is stay quiet, right? I'm sure that even if it was just a verbal argument, you feel terrible about what went down. Apologizing on a phone call that may or may not be recorded, sending a text message, apologizing to police, writing an apology letter, giving it to the police to give to the alleged victim. Listen, there's a time and a place to make amends if you did anything wrong. It's not during the investigation phase of a case. It's not without running that idea by a locally quality, experienced criminal defense law firm. Because short term, you may feel good about it. Long term, it may destroy any defense you have. It may seal your fate as it relates to any conviction. Second action step you should take is, in addition to being quiet, is retain a quality, locally experienced criminal defense attorney and criminal defense law firm. You want a law firm that's experienced in both years and in quality of cases, in volume of cases. A law firm that's seen your type of case before, that's handled your type of case before, that practices ideally exclusively criminal defense. My firm's a criminal defense firm. I don't know the slightest thing about trust and estates. I don't know the slightest thing about personal injury, but I know who to send them to. I know who to send our referrals to. I know who to send our potential clients to if they need something outside of criminal defense. You want to make sure the law firm you hire does criminal defense day in, day out, and particularly does it in the courthouse, at the very least in the county where your case will be heard. And the third action step is that if you have this parallel, family court case, right, you want to be mindful of how even a conviction, even being charged with a crime, can affect your child custody, can affect your, rights in a divorce, can affect your support, alimony, whatever the case may be. And you want to make sure that if you have a family law attorney, and you should, that your family law attorney and your criminal law attorney work well together. Ideally work with people who know each other, or who will at the very least be able to get along well and be able to effectively communicate, because that is very, very important to make sure that what we resolve your case for in criminal court, assuming an outright dismissal is not possible, has no effect, negative effect, on your family law case, and vice versa. So you want attorneys that are going to work well together with the common goal of protecting your rights, keeping you informed, and putting you in a better position in both the family court case and the criminal court case. Keep an eye on the big picture when we're talking about domestic violence restraining order hearings too. A lot of times people, I'm going to go all in on this domestic violence restraining order hearing. I'm going to go in and testify. I don't care if there's a pending criminal investigation against me. I'm going to go in and give a statement under penalty of perjury, under oath. Don't do that unless you talk to a criminal defense attorney, a quality criminal defense attorney, because the last thing you want to do is see those statements be used against you in a criminal court months after you made them in defense of a domestic violence restraining order hearing in family court. Hope you keep all those things in mind. If you find yourself charged with domestic violence, dealing with the domestic violence restraining order, or a combination of the two, feel free to give my firm a call at 619-295-3555, and we look forward to helping you assess your options moving forward and make the best decision for yourself, your family, and your future. 619-295-3555.